I'm the head of the firm's Health Law Group, and I wanted to welcome you to our program today. We're going to talk briefly about Idaho's new conscience/whistleblower statute. I wanted to make sure that you were aware of this because I think that there's some stuff in here that is very troubling and may impact you and your employment or credentialing decisions going forward. It'll be a pretty quick webinar, but let's launch into it. In 2025, the Idaho legislature enacted its Medical Ethics Defense Act, probably kind of as an outgrowth of everything that went on during COVID and provider conscience and the like. That's all found at Idaho Code 54-1301. It includes the conscience protections, but the part that's really troubling for me are the additional whistleblower protections that are broader than the conscience objections, and that's what I really wanted to focus on. The statute actually took effect in March of 2025, so it is in effect right now. As far as additional resources that we provided to you, I have given you a copy of the statute along with an article that I did talking about that. As we go through this, if you have questions, feel free to submit them. You can either use the chat feature or email me and I'll respond offline. All right, with that said, let's launch into it. Why should you care about this? Because it creates a new private cause of action that allows healthcare providers, and that's defined very broadly, we're going to talk about that in just a minute. It allows them to sue you for a violation of the act and recover injunctive relief. For example, if they were kept from employment or adverse action was taken against them, then they could be reinstated. If you took adverse credentialing action against them, then maybe you could get reinstated with their privileges, board certification, licensure, etc. In addition to injunctive relief, they can recover actual damages for any injuries that they suffered, and they can recover reasonable costs and attorney's fees. This new private cause of action is broader than the existing law that they would otherwise be able to use. All right, let's talk about each one of those aspects of the statute. The first is the conscience protections. Now, by way of background, this is not the only conscience law that's out there. For years, we've had federal conscience protections that apply. In addition, in Idaho, we have certain other statutes that provide certain conscience laws. Most importantly, there's a general provision that says that if a provider who for ethical or professional reasons is unwilling to conform to the desires of the patient or the patient surrogate decision maker, they may withdraw from rendering care. But before they do so, they've got to make a good faith effort to assist the patient in obtaining the services of another provider who is willing to provide the care requested by the patient. And in the meantime, they've still got to provide life-sustaining or comfort care if it's requested by the patient or the patient's surrogate, unless it would be non-beneficial care. Now that's been in place for a long time. The key there is that the physician simply can't just refuse to provide care. They've got to provide care while they attempt to transfer the care over to somebody else. There are separate conscience laws that apply to abortions, abortifacients, emergency contraceptives, and stem cell research or cloning, or end-of-life care. That's a specific one that's out there that's been in place for a while. And there's also a provision under the post statute that allows a provider to decline to comply with a post if it's against their conscience law. But none of these statutes create a private cause of action like the new one does. That brings us to the new statute, the Medical Ethics Defense Act. It states that healthcare providers cannot be required to participate in or pay for a medical procedure, treatment, or service that violates such healthcare provider's conscience. A couple of key terms there. What is a healthcare provider? Well, under this particular statute, it's any person, institution, so it's hospitals or others, or payer who is authorized to participate in any way in any medical procedure, treatment, or service. It includes, but is not limited to, doctors, nurses, aides, APPs, AHPs, allied health professionals, MAs, techs, psychologists, counselors, social workers, pharmacists, faculty, or students. But not only those licensed or certified healthcare providers, it also includes any employee of the hospital, clinic, nursing home, or pharmacy, a health institution, a healthcare payer. All of those are healthcare providers. So it's not just your typical licensed providers, it's also facilities and employees of any of those facilities or entities, even if they're not licensed. Now it applies to that healthcare provider's exercise of their conscience. What is conscience? Well, it means the ethical, moral, or religious beliefs or principles sincerely held by the healthcare provider. Well, where do you draw the line between ethical, moral, or religious beliefs versus political beliefs or other types of beliefs? Who knows? I mean, that could be at some point a bone of contention. So the first one is the provider can't be required to provide care or participate in care if it's against their conscience. The statute then says that another entity, any entity, cannot discriminate against a healthcare provider for exercising that right of conscience. And discriminate, again, is very broad. It says any adverse action taken against or any threat of adverse action communicated to any healthcare provider as a result of exercising conscience rights, including but not limited to any penalty or disciplinary or retaliatory action, whether executed or threatened. So it could apply to, adverse employment action, but it's broader than just employees. It could apply to adverse credentialing practices by a hospital or other healthcare facility or even a healthcare payer. It could apply to adverse contracting decisions with payers. It really doesn't limit who it could apply to. It's discrimination against a healthcare provider, but any entity that's discriminated against that healthcare provider. It could apply to licensing agencies and the like. Now, discrimination does not include the negotiation or purchase of or the refusal to use or purchase insurance or medical procedures, treatments, or services by an individual or non-governmental entity, nor does it include good faith efforts to reasonably accommodate conscientious objections of a healthcare provider. But essentially, it's this language about discrimination. It can apply to almost anything if that healthcare provider thinks some form of adverse action or they were damaged in some way because of the exercise of their conscience. Now, a healthcare professional, if they are going to exercise their conscience, then the healthcare professionals will communicate to the healthcare professional's employer a conscience-based objection when it occurs or as soon as reasonably possible to allow that employer to make necessary staffing adjustments without delaying the provision of healthcare services. In addition, employers may require an employee to disclose the employee's conscience-based objections at the time of hiring, so perhaps at the time of the application, but such disclosure shall not limit the rights protected by this chapter. So, for example, it raises the question, do you even want to ask an applicant about their conscience objections? Because if you take adverse action against them based on their conscience objections, then the employee may claim, or you refuse to hire them, then the employee may claim, or prospective employee may claim that you did so because of a conscience objection. So it may be one of those situations you really don't want to ask about it, at least until you've made the hiring decision, to avoid a situation where they claim that you took adverse action against them or refused to hire them or refused to credential them or whatever because of their conscience rights. The employer may require the employee to provide conscience-based objections in writing if you want, but again, it only applies to employers there, even though the statute itself is much broader. The statute provides immunity for healthcare providers who exercise their right of conscience. It says that no healthcare provider shall be civilly, criminally, or administratively liable for exercising the right of conscience. So, for example, a patient who's harmed may not be able to sue that provider because of the exercise of conscience, subject to some limitations we'll talk about in a little bit. Furthermore, no healthcare institution, so the hospital or other SNF or whatever, shall be civilly, criminally, or administratively liable for the exercise of the right of conscience by a healthcare professional employed, contracted, or granted admitting privileges by the healthcare institution. All right, so that's a broad overview of the conscience rights. I don't have too much problem with those conscience objections. I mean, it raises lots of questions about how do you provide effective care and the like, but we'll talk about that a little bit later. Overall, I'm okay with that, but the whistleblower protections are the part that really concerns me. So, there are some pre-existing whistleblower laws that are out there, some other ones. There's a federal statute that applies to federal employees who report government waste, fraud, abuse, or violations of laws or regulations. Idaho has its own government whistleblower statute, but it only applies to government employees who report waste of public resources or violation of the law. Those statutes don't apply in the private sector. There is in Idaho a wrongful discharge tort claim that they might be able to sue. It generally prohibits a discharge or adverse action that violates clear mandate public policy. For example, a policy that's clearly stated in a statute or regulation. But traditionally, the Idaho courts favor at-will employment agreements or favor contracts, and they are somewhat hesitant to push that wrongful discharge short claim, and so it's construed relatively narrowly. Then comes along this new Medical Defense Act. It states, in addition to those conscience provisions, it states that you cannot discriminate in any manner against a healthcare provider. And by the way, no one can. It's not just limited to employers. It could be contractors. It could be facilities that are granting privileges or the like. It says you cannot discriminate in any manner against a healthcare provider because the provider provides information regarding an act or omission that the provider reasonably believes to be a violation of the act to the provider's employer, the Idaho Attorney General, a state agency charged with protecting the right of conscience, the Office for Civil Rights, the Federal Office for Civil Rights, or other federal agency charged with protecting the right of conscience. Okay, you understand that. Also, you can't take action if they testify or assist in a proceeding concerning a violation of the act. Okay, but here's the kicker. Also, you can't discriminate in any manner, take adverse action against any healthcare provider because that healthcare provider discloses information the provider reasonably believes evidences any violation of any law, rule, or regulation, any violation of any ethical guidelines for any medical care. I'd probably even be okay with that, but it goes on to say any discloses any information they reasonably believe evidences gross mismanagement, abuse of authority, practices that may put patients at risk or endangers public health or safety. Well, the problem is that goes beyond the conscience objections, right? Now you've got employees, medical staff members, any contractors, anybody else. If they want to either defend against adverse action that may be taken against them, all they have to do is come up with some kind of a claim that, that action was taken against me because I disclosed gross mismanagement, whatever that is, or abuse of authority, whatever that is. It doesn't even have to be a violation of the law. Just this allegation of abuse of authority. That to me is very troubling. It seems like they can pretty much fit that into any kind of a box, and then it'll come down to a he said, she said about whether or not there is any kind of a disclosure or the intent for the action. Now, they still have to establish their cause of action, which appears to be, in order to establish their cause of action, they'd have to have a healthcare provider. But again, healthcare provider is very broad. It's not only licensed entities, individuals, but it's also employees at any healthcare provider entity. The healthcare provider has to disclose information the provider reasonably believes evidences, and note that it's the provider's belief, not necessarily your belief. It has to be a reasonable belief, but still, it focuses on the subjective intent of the provider, that they reasonably believe evidences violation of the law, rule, or regulation, or a violation of ethical guidelines or medical service, or gross mismanagement, gross waste, abuse of authority, or practices that put patients at risk or endanger public health. So it has to be related to one of those. But again, I think those are incredibly broad. That discrimination against the healthcare provider by anyone in a position to take adverse action. So there has to be some form of discrimination, adverse action against that provider who made that disclosure. And there has to be causation, meaning that the discriminatory action or allegedly discriminatory action had to be taken because the healthcare provider disclosed the information. The problem with that, though, is that's a fact question that may be very difficult to get out on summary judgment. And so it opens up this whole new private cause of action, a wrongful discharge claim in the context of healthcare providers. Now, there are certain defenses under that whistleblower claim statute. It does not apply if the disclosure is specifically prohibited by law. That probably doesn't apply too awfully much. The disclosure concerns the lawful exercise of discretionary decision-making authority. Well, that sounds pretty good, except there's an exception to that defense. It applies unless the healthcare provider reasonably believes that the disclosure evidences a violation of the misconduct prohibited by the section. That is a violation of the law, ethical standards, gross mismanagement, or abuse of authority. Note that that exception focuses on the healthcare provider's subjective intent. So it seems to me that pretty much swallows up the whole defense that would otherwise exist for discretionary decision-making authority. Because you're always going to have the provider who believes that disclosure evidences a violation of misconduct. So I think that exception is very problematic. Now, there are some additional defenses that we'll talk about in just a minute. Okay, so that's my concern. I may be a little bit like Chicken Little here. Maybe I'm overreacting, but it creates a new cause of action that I think in the healthcare industry could become very problematic. All right. There are other provisions in there in the Conscience Act. It provides for some free speech protections. It basically says that Department of Health and Welfare and the Board of Medicine or any other department or board regulating the practice of medicine cannot reprimand, sanction, or threaten a healthcare provider for engaging in speech, expression, or association that is protected from government interference by the First Amendment of the United States Constitution. So this would only apply to government entities who take action based on free speech. Maybe an example would be if you have an outspoken physician who is criticizing or taking a position concerning certain medications dealing with COVID, and there was a licensing board that may have taken action, hypothetically, of course, may have taken action against them because of their actions, which appear to be contrary to the standard of care. Well, this statute, I think, was designed to protect against those situations. Now, there is an exception that those licensing or regulatory agencies can take action if they demonstrate by clear and convincing evidence that the healthcare provider's speech, expression, or association was the direct cause of physical harm to the person with whom the healthcare provider had a practitioner-patient relationship within the 3 years immediately preceding the incident of physical harm. Otherwise, they need to be very careful about taking any action based on free speech. Not only that, but if that department or board receives a complaint that is based on speech, expression, or association protected by the First Amendment, and that complaint may result in the revocation of the provider's license, then the agency must provide the complaint to the provider within 21 days after receipt. If they fail to do so, then they've got to pay the provider $500 per day that the complaint was not provided after that 21-day period. All right, now, there are certain exceptions or defenses under the Medical Ethics Defense Act, which applies across the board. It would apply to both the exercise of conscience as well as those whistleblower provisions. The Medical Ethics Defense Act does not apply to or affect the healthcare provider's duty to comply with the community standard of care. The statute specifically says in that particular situation, and let me see if I can find it here just quickly. It says that nothing in this chapter, meaning that act, shall be construed as providing a healthcare provider with civil immunity for the failure to comply with the applicable standard of care. Community standard of care is described in Idaho statute. So patients could still sue a provider if that provider-patient relationship was established, that they could still sue the provider for violating the community standard of care, which could potentially include patient abandonment situations. Also, the Medical Defense Act does not apply or affect the requirements under EMTALA. So if you're an emergency room physician or otherwise covered by EMTALA, then you still got to comply with your EMTALA obligations despite your conscience issues. The broader conscience rights, to the extent that there are broader conscience rights provided in other sections, including those dealing with abortions and the like, then you would be able to rely on the broader conscience protections that are provided by those other state statutes. In addition, if you're a religious healthcare provider, like a religious hospital or the like, then the act does not prohibit that entity from their employment, staffing, contracting, administrative, and admitting privileged decisions consistent with such healthcare provider's religious beliefs if such healthcare provider holds itself out to the public as religious and has internal operating policies or procedures that implement its religious purpose or mission. The Medical Ethics Defense Act also does not apply to or affect the employer's right to take action if an employee is unable to perform any essential function. The employer cannot transfer the employee to a suitable alternative position for which the employee is qualified, and the employer is otherwise unable to reasonably accommodate the employer without imposing an undue hardship on the employer. That sounds like ADA standards for employees. So if that employee's job functions have essential functions that might run afoul of the conscience law, then that employer can take action if they satisfy those standards. Essential functions means the fundamental job duties of an employment position. For example, the position exists specifically to perform that function. There are a limited number of other employees who could perform the function, or the function is specialized and the individual is hired based on his ability to perform that function. The bottom line there, though, is if you're an employer, you're going to want to take a look to make sure if you can fit within that essential function exception if you're going to take adverse action against an employee based on their conscience objections. Note that this particular provision only applies to employers, may not apply to other things like credentialing or privileging decisions. All right, that is a brief overview of the statute. Some of the problems that it'll cause, obviously, it's potential liability, the chilling effect that it may have on you if you want to take action against employees and that employee just decides to defend themselves by raising or alleging that your action against them is based on the exercise of these conscience decisions or the whistleblower statute, which of course is broader than the Conscience Act. There's also potential problems with the adverse effect on patients and other staff at the facility. If a particular provider decides they don't want to participate in a particular kind of care, that's may leave the patient somewhat out in the job, out in the cold on those situations. But remember that EMTALA still applies. Also, that the Act does not necessarily protect that provider from civil immunity to the extent that they have a duty to provide care consistent with the standard of care. There's a real question about to what extent that the statute can be applied in the face of federal anti-discrimination statutes. For example, if a provider wanted to refuse to provide care to, based on sex or gender identity or other things that may be protected under federal statutes, then to the extent that those statutes do protect it, then presumably that provider could be subject to liability under federal discrimination statutes. You also have to be concerned about what are the contractual obligations. If you as a provider, maybe you have agreed to provide this care, but you've got providers who are refusing because of conscience, they may be protected, but it may not protect you as the employer or the facility in rendering appropriate care. All right, so a few things in closing, just to suggest that you may want to think about given the new statute. You should make sure that you carefully consider the ramifications anytime you're considering any adverse action against a healthcare provider. And remember, healthcare provider is very broad. It's not only licensed entities, privileged or credentialed persons, but it could include any employees. And remember, that's any action, adverse action against them. It could be employment action, maybe even just termination of contracts, credentialing and privileging, or other actions that may adversely affect them. You're going to want to educate key stakeholders about the new laws and the requirements. That would presumably include your administration, department leaders, management, human resources department certainly needs to know about this, medical staff leadership, medical staff services, legal departments, they need to know about this new law, and others who may be involved in taking decisions. Now, I'm not saying that you don't take decisions, if it's justified, but there's going to be a greater risk that the patient may, or that the person may come back and claim that that action was taken in violation of this statute. You might want to consider how you're going to implement this. For example, as part of your employment process or your application for privileges and the like, are you going to ask up front about conscience objections? At least employers can ask about that under the statute. But again, there's a risk in doing that because if you refuse to allow them to work or refuse to hire them, does that open up the door to that prospective employee suing you because of they think that you refuse to hire them because of this conscience objection, similar to an ADA claim or something like that. It may be that you want to go through the hiring process first, make the decision about whether to hire them, and then maybe ask for that conscience objection situation. You're going to want to update your policies and practices so that they address the exercise of conscience so you don't run afoul of the statute, including non-retaliation provisions, your employment provisions, credentialing and privileging processes and the like. You're going to want to continue to monitor developments as we see cases that come out and try to answer a lot of the questions or refine some of the language that's included in the statute. All right, that is it. I've got a lot of questions about how this will be implemented. Hopefully the healthcare workers out there don't know about this statute and may never bring it up, but I am concerned that it may become a way that healthcare providers use as a defensive tactic to avoid adverse action that you may otherwise want to take against them. If you have any questions about that, you're not alone, but feel free to email me or use the chat feature and I'll try to respond offline. Otherwise, thanks very much for participating in the program today.